Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Kyle Nazareth, the new Marketing Content Manager at Napa Legal.
Thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like this episode, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. And if you want to learn more what we're up to, see our resources, events, programs, support us financially, that is always most appreciated. And you can do all of that at www.napalegalinstitute.org. All right. So for this week, we'll be covering first, the state of Connecticut banned a nativity display in the Capitol building, despite allowing all other non-religious displays in the same area. Then we'll go and talk about the recently released draft of the report from the White House Religious Liberty Commission. And we'll wrap up with the continued legal battles, now over a decade old, I believe, of the Little Sisters of the Poor constantly fighting against the contraceptive mandate that started with the Affordable Care Act. So let's start in Connecticut, my home state, although no longer, but state of my birth. So here, it's a fascinating case, and I think it highlights a lot of the free exercise, establishment clause, the various cases and themes that we've been covering here over the years. So this started when the Family Institute of Connecticut applied, the Leslie Wolfgang, who's the director there, applied to display a small nativity scene on a table in the state capitol building. Apparently there's a program for this. They have displays at the Capitol that allows, various private displays and exhibits in public areas of the Capitol. There's a committee in charge of deciding which displays can be put up there. Noteworthy that the year before this application, the committee had allowed menorahs to be displayed in the Capitol, but then this committee responded to Miss Wolfgang and told her that committee policy does not allow religious displays in public areas by outside parties. Interesting. The committee went on to say that a nativity scene is purely religious and that displaying it would be an endorsement of religion. I think both of those are wrong, but we'll get to that in a minute. So on behalf of this woman, Miss Wolfgang, and the Family Institute of Connecticut, First Liberty sent a letter outlining that the committee is legally incorrect and that the committee is actually violating the First Amendment by prohibiting this display. So there's a lot going on. One of the central arguments here that the letter from First Liberty says that the endorsement of religion test that the committee cites in their policy is part of the Lemon v. Kurtzman test that was abrogated by Kennedy versus Bremerton. And so they're relying on a void legal precedent, and the committee's position is incorrect. And so the letter from First Liberty asked the committee to remove the policy from its book and allow religious displays at the Capitol. I think a couple things legally here. Again, there's a lot of interweaving arguments and legal concepts here, but I'm just going to highlight a few things. First, I think First Liberty is correct in its letter that the committee's position is legally incorrect. And not only are they wrong on the Establishment Clause, but that the committee has itself violated the First Amendment by maintaining something that is facially unlawful. Now, the First Liberty letter is focused on the free speech clause. You're right, it's viewpoint-based discrimination if you're allowing all of these types of speech in the public square. Literally, it's the Capitol building, but not allowing certain viewpoints, in this case, purely religious ones, I suppose. Although if you look into the facts, it's not all purely religious displays, I don't think, because they allowed the menorah, but then not the nativity. Hard to tell factually what's going on here, but I think First Liberty's right that if you want to go this free speech route, there's a viewpoint problem here. A couple other things. So I think, first of all, this claim from the one of the committee members in Connecticut that the nativity display is problematic because it's purely religious in nature and could be seen as government endorsement of Christianity. I think both of these are wrong. First, on a factual level, I'm very curious to hear the defense of why the menorah was allowed on display last year if that same policy was in place. If a nativity is purely religious and could be seen as government endorsement of Christianity, how do you distinguish that a menorah is not purely religious display and could be seen as a government endorsement of Judaism? I don't know. I think the only possible distinction you could try to make would be, well, a menorah has historical significance aside from purely religious symbolism, right? The story of the Jews surviving in the temple at the time of the Maccabees by the light of the menorah and so on. Okay, sure. But then the same could obviously be said of the historical significance of the Nativity, which is right a series of statues commemorating the birth of just objectively the most influential and important person in human history. So if you want to make the argument that um okay, this is purely religious and that's the problem. I mean, you could go that route, the Ten Commandments route, and say, no, there's historical significance that's secular aside from the religious significance. And I think you'd be right on the nativity. But I think that's an aside. I think the FIC, the Family Institute of Connecticut, they're correct that Connecticut's standard here is just wrong. Even if it is a purely religious symbol, that's fine. A nativity, first of all, is not the establishment of a particular religion, right? This is not a Methodist symbol being displayed when Catholic symbols are not, or something like that. Um, an establishment of religion, as I've hammered on about for months on this podcast, probably longer at this point, requires government support, funding, endorsement of a particular denomination over and against others, right? You'll see things like punishment for failure to adhere to that particular denomination. You'll see government funding of ministers. You'll see exclusion of other sects. A nativity is not even sectarian, right? It's common to all Christian denominations, Catholic, Orthodox, Protestants, and so on. Allowing it to be displayed in a government building is just obviously not an establishment clause violation in our post-Lemon world of reclaiming a sane definition of what an establishment is. It's just not an establishment. And further, it's hard to argue that it would be establishment of a particular religion because they allowed the menorah up too. So how can you say like, well, you're establishing what non-sectarian Christianity and Judaism, right? This is part of this modern reframing to make any support or display of anything religious an establishment of religion. That's just not what that means. So First Liberty is right that if the government allows displays in general, and those displays are classified as speech or expression, right, then this is clear viewpoint discrimination, likely a free speech issue. I think that's right. But I think also there's a big free exercise issue here, and I'd like to see that pursued either in this case or more generally. I think the line of reasoning in Carson v. Macon, I would like to see it expanded and applied to other situations past government funding programs. And I think it's plausible here, right? So if you bear with me for a minute, right? The court in Carson v. Macon held that if a public benefit, in that case, private vouchers for private school or public funded vouchers for private schools, right? If that's a generally available program for all school vouchers except for religious schools, religious people and religious organizations are being punished solely for exercising their religion, right? All comers, but not religious comers. That's a free speech problem. Sorry, a free exercise problem. The Carson v. Macon court was very clear about that, right? They say if there's a restriction like that on religion for something that is generally available otherwise, if that restriction is not required by the establishment clause, then it's likely a free exercise violation. That's the basic holding and reasoning in Carson. I think that could be analogously applied to situations like this, right? Connecticut allows private displays, apparently of all kinds, in its government building, unless they are purely religious. It sounds like echoes of Carson. It's a generally available program, right? Displaying your little scene or statues or whatever, but it only excludes religion. I think because allowing nativity scenes on government property is obviously not an establishment clause issue. The whole history of America, remember, is full of Christian prayers at government events, nativity scenes in the public square, crosses and Ten Commandments displays, right? This is clearly not an establishment clause problem. It's actually at the heart of our tradition. So therefore, I think excluding only religious displays, but allowing all other displays in this generally available program at the Capitol is arguably a free exercise issue as well as a free speech issue. So I think I'll leave that there. This case is pretty early on. I don't even think anything's been filed other than the letter from First Liberty. So keep an eye on it. And Kyle, I'd be curious to hear if you have any thoughts.
Yeah, definitely. So, I don't see how any other way that they could classify the menorah as anything but a religious symbol because the Supreme Court has literally called it a religious symbol, right? I think it was in County of Allegheny versus ACLU, where they say it's a religious symbol. So it'd be hard for me to imagine any other way. But I think what really shows this state legislative committee or whatever it's called, their animus against, I guess, specifically Christianity, is that Supreme Court Lynch versus Donnelly, they said that a creche could be displayed in kind of a broader scene that the city creates along with other kind of religious monuments, right? So if they had a menorah last year, They could have had a menorah this year along with the creche, or the nativity scene, along with I don't know, a crescent moon for Islam or something like that. And all those things together, right? That's not an establishment of religion, right? But so instead of choosing to be inclusive and including a lot of different religions, they choose to be exclusive and discriminate against religion. And they could have just included a lot of religions. To me, that really shows like the intention of this state legislative committee. And the second thing I get, do you have any comments on that, Frank?
No, I think that's right. It's hard to assume like there are really only two explanations for behavior like this from a committee. Like the one is animus against religion, which is you don't want to assume that, but I don't really know what else to assume because the only other option that I can see is like a real incompetent ignorance of the law. So, well, we have this policy. It's based on clear law, based on the establishment clause. Like you have all these lawyers working in the Capitol and nobody realizes that like anything that relies on lemon is dead. Come on. So I don't know, but I can't see anything other than anti-religious sentiment or like legal incompetence being responsible for these kind of continued hostilities to religion.
Yeah. And the other question I had while kind of listening to you and hearing about this case was I've always been a little curious or confused, I guess, about how exactly the court will define a religious symbol, right? So we define a nativity scene as an overtly religious symbol, but for some reason the Christmas tree doesn't isn't a religious symbol at all, even though there's a long Catholic tradition of having an evergreen tree to celebrate the birth of Christ. It was started by Saint Boniface, right? So that's something I've always kind of wondered about and wrestled with a little bit while reading some of these cases.
Yeah, I think that's it's a good point. I think I like the attitude of let's just stop talking about what's a purely religious symbol and what's not, because even if it is a purely religious symbol, it's allowed to be displayed in government buildings. It just is. Like,
Yeah.
I think Judge Ho said that in his concurrence on the first Ten Commandments case in the Fifth Circuit a few months back, where there was all this argument about this has secular historical significance and it's not just a religious symbol. He's like, just stop. If it's a purely religious symbol, it's still not an establishment clause issue. So I think that's yeah, it's a confusing question. Why the nativity but not the Christmas tree? But like I would just like this to stop and say that no, all of these things are actually fine under the establishment clause. Let's give it a rest.
Huh. I didn't know that Judge Ho said that. That's awesome.
Yeah, I'll find the opinion for you. Maybe we'll bring it up and confirm the record here in a future episode.
But the next story we're going to get to is about the Religious Liberty Commission report. So on May 1st, President Trump signed an executive order that established the Religious Liberty Commission. The purpose of the commission was to identify emerging threats to religious liberty by focusing on everyday Americans who face discrimination and to understand why that discrimination is occurring. And how they did this was they had 7 hearings over around 10 months, and the commission heard a bunch of witnesses kind of tell their stories of different instances of religious discrimination. And then on July 1st, so earlier this month, the Religious Liberty Commission released a full draft report based on those hearings and kind of provided an outline on the current state of religious liberty in the United States. The report's pretty long. I think it's around like 256 pages and has 14 chapters ranging on a pretty wide variety of topics. It really starts with the big picture and kind of making philosophical and policy arguments about why religious liberty is indispensable to human flourishing and kind of the American history and story of religious liberty, which I found really interesting. And then it moves on to some major areas where religious liberty is under pressure or stress today. And it's really packed with stories of people suffering from religious discrimination in faith-based institutions, in schools, college campuses, the military. Religious leaders face a lot of discrimination and in healthcare as well, many of which we've covered on our podcast pretty extensively as well. So it was fun to read some of those reports and kind of see the parallels between what we've been doing here at Napa Legal. And then the report closes with 12 recommendations, a few of which include eliminating the Johnson Amendment, which, for those who don't know, that forbids political activities by tax-exempt religious groups. And basically that means that the religious nonprofits could lose their 501c3 status if they engage in political activity. So eliminating that It also recommends compensating military service members who were discharged for refusing COVID-19 vaccines, which off the top of my head, a big story who that involved was Mike Berry at First Liberty. So love to see his reaction on that. Um, I think it also recommends allowing greater religious expression in the public square, which is great. Greater access to public money for faith-based agencies, and broader exemptions for those claiming conscientious objections to a wide variety of policies, the vaccine mandates, pronoun usage in classrooms, etc. Well, the two main points I found the most interesting from the report are really from the first two chapters, and those lay a kind of more introductory foundation for religious liberty. And Frank, feel free to chime in at any time too. I know you're going to have very great, interesting thoughts on this, but diving into it, chapter one kind of talks about it's titled "Religion as an Indispensable Support," and it talks about how religion benefits society. And one key quote I really pulled away that I really enjoyed was that religion offers moral standards to which government can be held accountable, keeping tyranny at bay. And I think that's a really underrated point that I was like very delighted to see. And that's because one, it makes a lot of sense. Um, Government and law are kind of neutral procedural mechanisms, right? Even though they have an aim or purpose towards the common good, they aren't good in and of themselves. So, for example, legislatures can pass really virtuous laws or really evil laws, right? But therefore, they need an outside morality to steer them in the right direction. And that's where religion or the church comes in, right? I think that's a very Catholic idea from the quote from the Religious Liberty Commission report, that the church is supposed to guide and limit the state and almost act as its conscience in some ways. That's one of the first foundational principles in Pope Leo XIII's Rerum Novarum and kind of Catholic social teaching in general, is that the church is necessary to address social, legal, and political questions. It's the duty of the church to do so. So I really thought that was kind of a cool connection between theology and jurisprudence, and I was really delighted to see that in the report. Frank, did you have any thoughts on that?
Yeah, it's interesting. I have a lot of thoughts, but I'm going to probably just contain myself in the interest of time, more than anything. I like I like a lot of the proposals. It's always just a question of political will, right? Because a lot of the practical stuff is really important. Eliminating the Johnson Amendment is like something we've been talking about for decades. Congress just needs to have the will to do it. A lot of prominent people, not just like extremely religious folks, think that it's probably unconstitutional in the first place, but it's been so hard to challenge. Um, Greater religious expression in the public square is something that we've been fighting to chip away at and expand, for the last few decades with a lot of good success. Um, I guess my and one other, like the greater access to public money, broader exemptions. This is the stuff that the money I understand. But I think especially the broader exemptions for religious organizations, religious people, to a lot of secular or problematic policies, like very much want to focus on that. And again, I won't take a lot of time here, but I've been thinking a lot recently about this kind of what is the role, like you were saying, what is the proper role of the state in supporting, fostering, encouraging, or at least not preventing the work of religion. Um, and it's hard because there's not a government solution to the decay and decline of religion. You can do things to encourage it for sure, but I think one of the really interesting experiments of the last however long the Fidesz government was in power in Hungary, right? 15 years of like really aggressive like promotion of Christianity, opposition to and stopping of a lot of like hostile secular left-wing ideologies, faith and family formation, like financial support for having more children, all in an effort, like Orban had said, not to make this political, but now he's out of power, so it doesn't really matter anyway. But like this is an attempt to preserve Christianity and like Christian culture in this country. And I'm obviously not from Hungary, and I'm relying a lot on Rod Dreher's work, having lived there for 5 years. It's like it was an interesting experiment. It didn't really work. Like Hungary's people are not really more Christian for it. So it's anyway. I'm just kind of musing on something I've been thinking a lot about, but Obviously, I'm all for attempts to promote faith and family and children and greater expression of religion in the public square, but I think ultimately the key is allowing the space for vibrant religious organizations and institutions to flourish, right? So that's a lot of what we do at Napa Legal. Like, how do we ensure that these religious organizations, right, the schools, the churches, the pro life pregnancy centers, the charities of various kinds, are not burdened by the government, so they have as much freedom to flourish and rebuild the church and a strong society as possible. I think I have a lot more hope in solutions that are trying to do that to make it as easy as possible for these people and organizations to do their work rather than direct government intervention. And to be clear, like this report doesn't recommend a ton of like government intervention into religion, but just thought I would throw all that
Yeah.
out there.
Yeah, the report, for those who are concerned, explicitly says we are not recommending a theocracy. So
Right.
let's take that off the table. But I think that's an interesting point you bring up too, because probably a lot of people when they hear that kind of language, or the language of the report says even building a bridge between the city of God and city of man. I think a lot of people jump to the idea that okay, we're going to have bishop, whatever one of the bishops as the congressman or something like that, and that's not what this report's saying. That's not even close to what I would think the Catholic view is. I think it's really that very simple. The church teaches on faith and morals, right? But then it also, like you said, leaves practical, kind of technical, legislative formation or exactly, like policy analysis to the groups that have the competence to do that, right? So, like groups like I don't know, different lobbying groups or even who give advice to different Catholic nonprofits like Napa Legal, right? I think the church obviously can speak on abortion and things like that, but specific policies and the specific details of those um, are a little more nuanced and sometimes out of the church's competence. So I think that's an important distinction to note, and that keeps it from being the what people worry about, right? This theocracy or whatever they want to call it,
Yeah.
scare quotes.
Right.
But yeah,
Yeah.
anyway,
Yeah. I mean, yeah, I think we can leave it there, but I think that's right.
yeah,
I mean, there's no serious recommendation that looks anything like we need, government sponsored Christianity and punishing dissenters. That's like that's in the minds of secular opponents of religion. That's not really on the table from anybody serious in the
yeah.
White House or in the government or in the religious freedom movement in general. So,
Exactly. Yeah. And just moving on, I think the chapter I mainly wanted to discuss was the second chapter on religious liberty and the American story. Because, it's America's 250th, so we got to go over some good old American history. But really, they start with faith in the colonies, and they start out that the colonies did have state establishments of religion that included, levying taxes to support state-favored churches, banning or restricting competing denominations in churches, making church membership a prerequisite for holding public office. There's religious tests for office, and I just want to remind everyone that these laws were not kind to religious minorities, especially Catholics at the time, who have a very long history of being a religious minority in this country. Like the state of Virginia prevented Catholics from holding political office by requiring loyalty oaths that renounce transubstantiation. Massachusetts barred Jesuit priests from entering on the penalty of death, actually, at first. So these state establishments weren't bad just for religious liberty in a pluralistic society. They're also bad for a Catholic minority and any other denominations who weren't Anglicans or Puritans, pretty much. And then later in the report, we get into the ratification of the Constitution up through the early 1900s. Um, I was a little disappointed in this section to see that the only substantive analysis of the First Amendment in the first 120 years since its ratification was this, that the report says that the First Amendment originally only applied to the federal government. But beginning in the 1920s, it was incorporated to apply to the states as well, holding every level of government accountable for upholding the basic guarantees of religious liberty. I really wish they had taken more time to flesh out some of this historical context, mostly because most people reading this are not going to have any idea what that means, and they're going to completely miss the history and purpose of the First Amendment, which is very important for any religious liberty litigator or student of the First Amendment to understand, especially now that the court's using this history and tradition approach or test for constitutional claims. Just briefly, what I think they're trying to say really is that the Establishment Clause started out as a federalism provision, right? We talked about kind of a little bit how after ratification, 9 states had state established religions. The longest standing one being Massachusetts, actually. It had a state established religion until 1833. And the text of the Constitution, right? That language about Congress making no law respecting establishment of a religion, that was meant to bar Congress from creating a national church or interfering with state religious establishments. And that's where we get to that big SAT word, anti-disestablishmentarianism, right? I think I know what it means, but don't ask me to spell it. But it's basically saying this concept that religion was supposed to remain in the domain of the states. And whether it was establishment or disestablishment, it was supposed to be a state issue, not covered by the First Amendment really at all. And you see this kind of reflected in the Constitutional Convention debates because there really was hardly any discussion on religion during those debates. It was a pretty controversial topic that none of the founders really wanted to talk about because it would have completely blown up the debates and everyone would have gone home. So James Madison, being one of the main drafters of the First Amendment, he was a very strong proponent of disestablishing state governments. You could see that from the earlier Virginia Declaration of Rights debates and in his memorial and remonstrance. But he viewed the federal provisions of the First Amendment a little differently. During the Constitutional Convention, he was asked about whether the Constitution would give the federal government too much power. And he responded by explaining that it was an amendment on to limit the federal power of government. So there's a lot of scholars. It's not just me just saying this. There's a lot of scholars who have this perspective as well. Robert George, Akil Amar, Kurt Lash, Carl Esbeck, Daniel Drybeck, and Justice Clarence Thomas, most famously, and Justice Potter Stewart as well, all agree that it was supposed to be a federalism provision. And it really wasn't until the 1900s when the Supreme Court applied most of the Bill of Rights to the states through the incorporation doctrine in the Due Process Clause of the 14th Amendment that the First Amendment was going to be applied to the states. And the first time that happened was in the Everson case, right, where the justices said that Jefferson's wall of separation applied to the states for one of the first time ever. And actually, an interesting fact is that in Justice Rutledge's private notes, he had written that after the justices decided the case, they said that the real purpose of the Everson case was to keep like Catholic influence out of public schools. Because remember, in the Everson case, that involved a Catholic school getting public money or public benefits, pretty much. So, yeah, I think that history of the Establishment Clause is really important to note. And I guess that I wish they had touched on that a little more. But overall, I think the report was really well written. It was pretty robust overall and an effective defense of religious liberty and kind of a good laying of the ground of the state of it today. Um, I guess if my only criticism is that I wish they had included some of my favorite authors' analysis, like Philip Hamburger or Vincent Munoz. That's my only criticism. I think they did a pretty good job, pretty much. And then one of the 12 recommendations of the report is to instruct the Department of Justice to issue guidance clarifying the proper understanding of the Establishment Clause and the separation of church and state. So I'm really interested to see what the DOJ is going to say about that and the way that goes.
All right. Well, with that last thing I'll say is just a thank you to Mary Margaret Bush, our former executive director and my first co-host of this podcast, who was the director of the Religious Liberty Commission. I know it was a monumental effort to organize all these meetings and get the speakers in and the witnesses and the interviews, and then to produce this massive report. And a couple other friends of Napa Legal were also instrumental in generating this report, but I don't know if their identities are public, so I will not say any other names and just thank everybody for, especially in the Napa legal world, for their work on making this happen. All right, quick update on our third case. I don't want to spend too much time on this because this is never ending and it's not over yet. So we'll continue to cover the poor little sisters of the poor, who are again in court now appealing in the Third Circuit in yet another legal attack. So I don't think we need to give much background. I think everyone listening to this knows the Little Sisters of the Poor. They were fighting the Affordable Care Act over a decade ago with the contraceptive mandate that was requiring them to provide contraceptives in their, employee health coverage plans or else face millions of dollars in fines. The sisters have been to the Supreme Court and won, I believe, 3 different times, including a ruling that exempts them from the mandate in the Affordable Care Act requiring the contraceptive provisions, and yet we're still here. The original mandate, right, exempted secular organizations for some like administrative convenience purposes, but provided no exemption for religious groups. In 2016, this went up to the Supreme Court, ruled in favor of the sisters. In 2017, the federal government issued a new rule for exempting religious groups. The states, again, almost a decade ago, various states sued, seeking to force the original mandate to take effect, and they basically attacked on a number of administrative grounds the exemption for religious organizations. There's a lot going on there. I don't want to spend too much time on it, but basically the sisters fought that new suit up to the Supreme Court. Supreme Court ruled 7-2 that the Affordable Care Act did provide the authority to provide this exemption for groups like the Little Sisters of the Poor. Went back down to the district court on remand, and the states claimed that the rules that allowed the religious exemption were arbitrary and capricious, insufficiently reasoned. They also threw in that the contraceptive mandate supposedly did not substantially burden religious exercise, which I'm sorry, that's ridiculous. But in the process of that last round of litigation on remand, federal government requested that the case be paused while it evaluated the issues of the claim. It's been on pause. It was on pause for years. And then it resumed in, I believe it was 2025, late 24, early 25. There were cross motions for summary judgment. The district court ruled that the exemptions from the rule that allowed the Little Sisters to get out of the contraceptive mandate were arbitrary and capricious because the agencies in charge of the rules didn't provide a reasoned explanation. They also agreed with some of the other arguments from the state. And so now this is on appeal in the Third Circuit, and here we go again. So a number of prominent attorneys, Paul Clement and Aaron Murphy at Clement and Murphy, Becket, and attorney Nicholas Centrella, all were involved in defending the Little Sisters of the Poor. So their names are all on this appeal to the Third Circuit, which was filed on July 7th, arguing basically that the court erred in ruling the exemptions to be arbitrary and the exemptions to violate the Administrative Procedure Act. So there's a lot going on. It's almost a 100-page appeal. I'm not going to go through all the points. I just want to touch two real quickly before we wrap up. So first, the sisters and their attorneys argue, which I like this argument, that first of all, there's no legal injury here to the states trying to enforce this mandate. I think this is legally correct, but it also brings up a major like policy or almost philosophical issue here. This isn't hurting anybody. The Little Sisters of the Poor, a Catholic organization, they're an obviously Catholic organization. It's sisters who run these nursing homes that serve the elderly poor in particular, right? It's a faithfully Catholic environment. I don't know if you've ever been to them, Kyle. I've been to their nursing home in Scranton a number of years ago, and it's there's a chapel. They wheel in a lot of the elderly there to mass every day in the chapel. That you have nuns taking care of these people. They're really focused on bringing in people who don't have the money for nursing home care and who don't have family to take care of them. So it's really a beautiful work of mercy what they're doing, but it's an obviously Catholic environment. There's just no reason that they should have to provide contraceptive coverage to their employees, right? People who want to work in a place like this are asking to work in a Catholic environment. It's clear from the place that you're applying for employment at. There's no reason you should expect Catholic nuns to pay for your artificial birth control and your health insurance. That's just absurd. If that's an expectation that you really need artificial birth control covered in your healthcare plan, you can go work somewhere else. So this is a false problem, as far as I can see, used by governments to try to make secular ideologies, um, that oppose openness to and protection of human life mandatory. This is not about choice. This is about you will comply with the anti-religious, anti-life message, or else. I can't see any other way around it. And the other thing I just want to point out is I think the most important legal argument in the appellate, the appeal that was just filed. So basically, if the state's argument is successful that there was something defective in the religious exemption promulgated to the Affordable Care Act, there's now a religious liberty problem, right? The states argue that the rule granting the religious exemptions it's arbitrary and capricious, it's insufficiently reasoned. Okay, fine. I think there's a good argument that that's all incorrect, but even if it were correct and now the religious exemption rule is absent, the sisters argue rightly that the contraceptive mandate without the religious exemption now violates RFRA pretty obviously. Um, so it seems to be, again, just another way to harass these poor sisters who are doing excellent and needed work in the community. Um, if the final rule is invalidated, then the contraceptive mandate now has a problem and that it doesn't comply with RFRA, with the law requiring the government not to substantially burden religious exercise. This argument that the contraceptive mandate is not a substantial burden to religious exercise is absurd, right? I'm sorry, the sisters have a legitimate Catholic opposition to artificial birth control, mandating that they have insurance plans or provisions in place that make sure that their employees have coverage for such immoral things. It's certainly a substantial burden on religious exercise. So I think that's kind of a throwaway argument. Like the states here are hoping that they can win on the APA administrative arguments and spiral so that this thing continues for another level of legal argument and keep the poor sisters in court for another couple of years. But the way I see it, I mean, this is pretty obviously, if you have the mandate without the exemption, you have a religious liberty problem. So I'm pretty confident that the sisters will prevail eventually again. But it's a travesty that they've spent over a decade in court fighting this like burdensome, unnecessary contraceptive mandate that's really not. It doesn't serve any major purpose. There are other avenues for people to get birth control if that's what they want. And the sisters should be devoting their time and their energy and their resources to their mission, which is serving the elderly poor and not fighting, racking up Supreme Court wins.
Mhm. Yeah, I think, so to the point of the whether providing or having insurance that provides the ability to, get birth control, whether that substantially burdens religion, the counter argument pretty much that they would say, I think they mentioned this in the original case actually was, well, you're just providing the insurance plan and the actual employers are the ones who get to decide whether they're electing to, you know, get birth control through this is the in health insurance or not. So it's really not a burden on your religion at all. But I think that's a really flawed kind of reasoning. One, because money's fungible, right? So even if you do provide, you know, money through this health insurance in some way, you are kind of materially cooperating with it still. You're still kind of allowing through your money in some way providing for this birth control. And even if you disagree with the material cooperation elements of it, that is their sincere religious belief, and it's pretty clear from there that it substantially burdens the little sister's religion.
Yeah, I think that's a good point to end on. I think it raises a lot of the things I'm currently working on church autonomy questions, or maybe raised there too, for the government to come in and say, well, okay, if you were directly funding a plan or directly funding contraception, that's one thing, but you don't even want to participate in like opting into a plan where the government's paying for it. It's like at this point, the government is coming in and telling the little sisters how they ought to view their cooperation with something that they think is immoral. And to me, that this is a question of doctrine about how they live out their beliefs. And it seems inappropriate for the government to come in and say, like, no, sisters, this is the way, that you would comply with your beliefs on contraception. You're going too far. Like, it's not the government's business to make that call. And with that, I think we'll wrap up. So, thank you all for joining us for another episode of the Napa Legal Weekly Podcast, where we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom, the work of faith-based nonprofit organizations. As this episode is coming out, we will be heading to Napa for our Napa Legal Nonprofit Summit and then the Napa Institute Summer Conference. So we may have an odd week where you don't get the normal episode next week, but we look forward to talking to you soon. So thanks for joining us, and God bless you all.